Hi, good afternoon. I'm Joel MacMull, and we're dusting off the musings this afternoon because I want to take a few minutes and talk about an issue that was on appeal for the Court of Appeals for the Second Circuit. And the issue concerned a long-standing trademark dispute that I've been involved in on behalf of my client, a winery in Napa by the name of Pejou Province Winery. The principal issue on appeal was the following. Was Pejou precluded from defending itself against a likelihood of confusion claim where 13 years earlier it had been denied its registration for the mark Liana? Well, in this case, the district court decided in December 2017 that indeed Pejou Province Winery could not re-argue or relitigate the issue of likelihood of confusion. Both in that proceeding, and I was not yet counsel of record, and throughout the course of the case over the next 7 years, that was a central issue that was led really to a cascade of errors that were committed by the district court. So what is issue preclusion? Issue preclusion as a concept is the idea that an issue cannot be relitigated if it was previously litigated in a prior determination. But there are a number of things that have to happen for issue preclusion to apply. And the Supreme Court has set forth a either 4 or 5-part test, depending on how narrow some of those factors may be or how they may be interpreted. But in the Second Circuit, it has it's fashioned its own test that really is just a riff on the Supreme Court's test. But two things are really critical to that test. Number one is the issues have to be the same. Were the issues actually litigated? That's part of the analysis. The other thing that the Second Circuit adopts, and has, I think, better language, dare I say, than the Supreme Court, is that the party against whom issue preclusion is to be applied had a full and fair opportunity to litigate the matter in the prior proceeding. Now, those were two issues that we argued on behalf of Pejou, namely that the issues were not identical 13 years earlier when they were before the board, even though there was a finding of a likelihood of confusion, a finding, by the way, in connection with a proceeding that really did not provide for a full and fair opportunity to be heard. Specifically, as we argued before the Second Circuit, there was no notice that was ever supplied to Pejou. So when the plaintiff in both the board proceeding and in the later district court proceeding proceeded to file a motion for judgment on the pleadings wherein it attached a copy of its registration, the Trademark Trial and Appeal Board converted that into a motion for summary judgment. But in converting it into a motion for summary judgment, and contrary to its own manual of procedures, as well as Federal Rule of Civil Procedure, Rule 12D, which mandates that where the court or a tribunal may be considering matters beyond just the pleadings, a party must be afforded the opportunity to submit evidence that may be relevant to the motion. In this case, notice was never provided to Pejou. And so our first line of defense was these were not fair and full proceedings. And the Second Circuit seemed to sort of recognize it was a real problem there. The other issue is, and this was the second issue that we argued in connection with our appeal, although our appeal actually contained 4 issues, was marketplace usage actually assessed in the prior board proceeding 13 years earlier? It was very clear from the record that the board did not consider any sort of marketplace usage. And the reason why that's important is, for those of you that are familiar with B&B Hardware, it mandates that if there is going to be issue preclusion between a board determination and a subsequent trademark infringement case, the board must necessarily engage with a sort of fulsome analysis of marketplace usage. That's very clear from the opinion. And again, back in 2004, when this board proceeding that's relevant to my case occurred, this is, what was it, 11 years before B&B Hardware? So no, there was not an engagement with real marketplace usage. And thankfully, the Second Circuit appeared to sort of comprehend that as well. So this is a particularly interesting case for I guess really the following reason at least. which is that since B&B Hardware, and specifically the Eighth Circuit on remand, which in that case found that there was issue preclusion because real world marketplace evidence was considered, the Second Circuit has before it, I think, the only time, at least that I'm aware of, that a court of appeals is assessing really the breadth of B&B Hardware and whether, I guess fundamentally, whether it really means what it says. So in a nutshell, that's it. In a prior post, I actually included a link to the oral argument if you're interested. Thanks for listening, and hopefully this will be the first of a couple of refreshed musings in the weeks to come.